Good evening, Madam Chair and Senators. I'm Attorney Jayne Brockman from Westerly. I'm here to provide testimony on why Senate Bill 152 is a grotesquely extreme bill. While it certainly would expand the abortion industry here in Rhode Island and benefit them financially, it does nothing to advance women's reproductive health, and I emphasize health. In fact, the bill actually threatens women's health and safety, and it should not, therefore, become law. I believe you should have a copy of the legal memorandum written by Attorney Paul Linton, providing a thorough analysis of the identical bill to House Bill 5125 sub A. It hasn't been mentioned, so I wanted to add here that Paul Linton is a highly regarded constitutional law attorney. He has represented amicus curiae in landmark U.S. Supreme Court cases, including Webster versus Reproductive Health Services, Planned Parenthood versus Casey, and Gonzalez versus Carhart, to name a few. He has also submitted briefs in most of the federal courts of appeals and a majority of the state Supreme Courts in the United States. Mr. Linton has published 19 law review articles on a variety of topics, including the history of abortion regulation, and in 2012, he published Abortion Under State Constitutions, a state-by-state analysis, which is a meticulously researched, comprehensive guide to the status of abortion under each state's constitution. Mr. Linton received his undergraduate and law degrees from Loyola University of Chicago, and he clearly qualifies as an expert, if not the expert, on abortion legislative analysis, so I would strongly encourage you to read his analysis carefully. Senate Bill 152 purports to codify the current state of the law on reproductive rights in Rhode Island. I'm sorry, let me quote exactly. It purports to codify the privacy rights guaranteed by the decision reached in Roe versus Wade and its progeny. This is a lie. This bill expands the abortion right far beyond Roe and its progeny. In fact, all reasonable restrictions on abortion, including those to protect the life and safety of women, will be deemed prohibited, and the statute will provide ammunition to defeat even the most reasonable restrictions. The statute is laden with ammunition for the abortion industry to defend any challenge to this statute. And I will go into that further. It's called the non-interference principle. But first, I want to remind the committee the trimester scheme set out in Roe versus Wade. In the first trimester, the court held that the state has no real interest in protecting the mother's health, but it can require basic. It didn't have a strong an interest in protecting her health because it was a first-term abortion, small baby, and the risks were low. The state can only require basic health safeguards and cannot limit access to abortion. In the second trimester, the state has an interest in protecting the mother's health, and in the third trimester, the state has interest in protecting potential life. That is Roe versus Wade. That's nowhere in this bill, not anywhere. So it's not codifying even Roe, let alone its progeny, but we'll get to that. The other thing I want to mention about the progeny is that the Supreme Court has upheld things that are not contained in this bill, such as state-mandated counseling, waiting periods, gestational limits, and things of that nature. This bill doesn't have any of those. This bill just blows through any kind of restriction that you could put on the right to abortion. As to each provision of the statute, I would encourage you all to ask yourself, as to everything that's removed from the bill, as to every reasonable requirement that the bill fails to preserve, and as to each new provision it seeks to anchor in our law, ask yourself, who does this provision benefit? Is it Rhode Island women and their health, or is it Planned Parenthood and the multi-billion-dollar abortion industry? You see, the abortion industry would have you think that their interest lines up perfectly with women, but their interests don't align with women. They hide their legal maneuvers behind a woman's right to choose, so you don't even notice that a particular liberal abortion measure is really intended to benefit only them and put money in their pocket. This statute takes wide swaths of current reasonable abortion restrictions and summarily mows them down for an essentially unlimited right to abortion. And in its place, this bill plants an invasive weed, the kind that takes over and kills all good plants in its way. This invasive weed...
I just want to let you know that you're at about 5 minutes now, so if I can get you to kind of try and wrap up so we can get to Mr. Kavanaugh and everybody else, please.
This invasive weed is the non-interference principle, whereby the state is largely prevented from restricting the abortion right, and if they do, the statute provides plenty of ammunition for the abortion industry to fight it and win. Proponents of this bill would say, but there is a provision that says nothing shall be construed to prevent the Department of Health from applying to licensed healthcare facilities that perform abortion any generally applicable regulations or standards. Except that it then says, provided that such application, adoption, and enforcement is not pretext for restricting abortion. So rather than preserve the state's right to enact reasonable restrictions that was established in Roe and followed by its progeny, the statute simply reinforces the wall around the abortion right. And that wall is impenetrable. And that's what it's designed to be. Because after all, this statute was intended to protect Planned Parenthood and protect the abortion industry in the operation of their business. The non-interference principle, the language is very broad, and like I said, I want you to focus in on that that language. It's essentially 24 4.13-2A, at the end of which it has that mention of pretext. I want you to focus in on that and see just how it operates. First of all, the state would not be able to apply generally applicable regulations and standards. It may apply generally applicable regulations and standards, but any ones that are specific to abortion, no matter how reasonable, no matter how justified, to protect the health and safety of the mother, will be shot down, because that's what this law is intended to do. Second, the term pretext as a standard is ambiguous, vague, entirely subjective, and is not constitutionally required by Roe or its progeny. In fact, it's so subjective, whose perspective is going to determine whether a given regulation or a standard is pretextual. In effect, the statute elevates abortion to a special protected status, like, for want of a better word, a legal sacrament, that just the mention of the word causes all common sense and reasonable regulations on this multi-billion-dollar industry to fall. Abortuaries become a fortress and a law unto themselves.
Ms. Brockman, can I ask you to wrap up, please?
I will focus in on some of the things that hurt the women. For example,
Respectfully, point of order. We've got 300 people here tonight, and if the chair is imposing a time limit, really, we're at 10 minutes now. I don't mean any disrespect, but we're going to be here till 11 o'clock tomorrow morning, if that's the case.
well, this is what's under consideration, is the statute, so
Well,
I thought it
I
was
understand
important that we lay the groundwork.
If people begin to, respectfully through the chair, if
Sure.
people are going to begin to start reading treatises, please submit the written treatise. I promise you, we will all read it. I promise you that. But we're going down a very slippery slope here, because if we allow everybody to start speaking for 10 minutes, we're going to go on and on and on through the evening, respectfully.
Well, again, then I will close with asking yourselves, if non-physicians can perform the abortions, is that to promote the life and health and safety of women? If these abortions are going to become more and more later term, and all the serious complications that come with those. Is that for the life, health, and safety of the woman? This is all for the abortion industry, and none of this is for the health and safety of the women. So please do focus on the women, and do focus on how this statute is simply trying to protect the abortion industry. Thank you.
Thank you. Any questions or comments for this?
Madam Chair, just,
Senator Abtakis.
Can we get the letter that you stated, I think even the first witness, about the attorney that, I can remember the...
Paul Linton?
We don't have it here in the packet.
Oh,
Do you have a
I
copy of it?
apologize. I assume that Rhode Island Right to Life had provided that to you. I will get that right to you as soon as I
If you
leave.
can,
Okay.
if you have the letter with you right now, we can have one of our staff members reproduce it so we can see it, because you're the second witness that mentioned that letter, and we have no
Thank you,
copy
Mr.
whatsoever.
Kavanaugh. We'll get
Thank
it.
you.
We'll
I
get
will
a
get
copy.
that for you. Yes. Thank you.
All we have, I'm sorry, through the chair, all we have are letters from various constituents. We have no, any
Okay.
written memos or
Oh,
anything.
we apologize. We
of that
thought you
nature.
had it because we'd be following along with us.
And some of them may have been emailed prior that the
Oh, okay.
members just didn't bring all of the information that has been given. You've got to understand that over the past probably
yeah.
5 years, we've gotten consistent information. So what we do have in front of us is the bill and the letters that were sent specifically today as testimony. So anything that anybody wants to provide, we can make sure that our staff can get copies to us. We have plenty of time. We're going to be here for a while, so
We will
be
get
able
that
to
to
read
you
them.
right away.
Thank you.